Good morning, everybody, and welcome to our webinar this morning on how serious allegations can be handled safely. So before we start, we would like to introduce ourselves. For those of you who have not joined any of our previous webinars, I'm Victoria Templeton, one of the HR Knowledge Managers here at HR Solutions, and I'm joined today by Sue Watson, Head of Client Services, who will be supporting in our polls and also fielding questions at the end of the webinar. A team shall also be supporting in the background to deal with any technical issues. And do let us know if you do have any questions as we go through the webinars. We always like to welcome questions on the subject. Obviously, we've got many of you on the webinar today, so for obvious reasons, you all are placed on mute. But in terms of wanting to raise your questions, then we will be taking those at the end of the webinar. So what we would like you to do is just note any of your questions in the comments box as we go through the webinar. And here's a quick guide to show you how you do that. You can ask the questions via GoToWebinar panel, and it should look like this that's showing on your screen. And then please type your question in the question pane and we'll aim to read out and answer as many as we can. We want to make the session as interactive as we would normally at our physical events. So we will be, as usual, running a series of polls throughout the session as well. So when we have a poll, you'll see this screen come up, and then GoToWebinar will prompt you for an answer to the question. And in order to participate in the polls, you just need to ensure that your screen is not in full screen mode, as for some reason the poll system doesn't work on GoToWebinar when you're in the full screen mode. And they're the introductions out the way, so I'd like to begin on today's webinar. And I just want to run through what I'll be covering today. And so we'll begin with first looking at what we actually mean by serious allegations and consider how these can arise in the organisation. I'll then move on to cover the risk from an employment tribunal claim perspective in regards to serious allegations, whether they're not properly managed or not managed at all. Before I will then talk through the various key actions that we think are essential for you in managing serious allegations safely to help prevent tribunals, or where you do still end up with a tribunal claim, what steps you should take that will help go on for you to go on and defend your case should you be in that tribunal. But first I'm going to begin with a poll. So I'd just like to ask Sue to launch the first poll for us.
Okay, here we go.
Thank you, Sue.
So, which allegation would you dismiss for? And you can select more than one here. So, out of these that are listed. So we've got absence from work without permission, failure to adhere to rules, bad behaviour, failure to notify promptly driving licence endorsements, minor breach of cash handling procedures. So this is what you would dismiss for. Collect a few more votes.
Thank you.
Nearly there.
Yeah.
Okay, we'll close the
Thank you.
voting now. And I'll share the results on the screen.
So what do we
have? Wow, we've got 69% for failure to adhere to rules,
yep.
Then for bad behaviour, followed by absence from work and failure to notify promptly driving licence endorsements, and then we've got.
Okay, thank you for that. That's a really interesting poll, and interestingly, on the face of it, there are, these kind of allegation titles could quite easily be misconduct breaches, and therefore not dismiss. And what this next section is going to do is to help you identify actually what is serious and what do we mean by gross, and therefore what can you dismiss. So if we think about these examples there from the poll, depending on what's happened and the circumstances, and some of the information I'm going to share with you now, they actually could become more serious and warrant being pursued as a gross misconduct. But on the face of it, you know, for example, a minor breach of procedures, you wouldn't necessarily dismiss. So it's kind of interesting because it's a thought-provoking poll, I think, and I'm going to come on now to sort of clarify more about the differences, misconduct and gross, because this sets the context for actually then managing serious allegations. Thank you, Sue.
I'll hand it back to you.
Brilliant. So I'm now going to look at what is a serious allegation. So first of all, it's really important that you do determine whether the allegation is of a misconduct or gross misconduct nature. And it's really important because one has, for obvious reasons, very serious implications for continued employment relationship. So in terms of misconduct allegations, these relate to matters which contravene your rules and regulations. But overall, in the context of the employment relationship, whilst they may weaken that relationship, they're not serious enough to justify breaking the contract and dismissing for that first offence. Gross misconduct, on the other hand, is a form of misconduct, but it's of extreme and abnormal nature, and even criminal. Gross misconduct allegations are so serious that it constitutes a fundamental breach of that contract, which, you know, irrevocably destroys the heart of the contract, and therefore it becomes a matter in which the employer cannot reasonably be expected to continue employing that individual any longer. So for the purpose of today's webinar, I am going to be focusing on the gross misconduct allegations. So by that I mean matters such as your theft, fraud, violence, acts of bullying, harassment, you know, the ones that we're seeing here on the screen, dishonesty, alcohol and drug abuse. But of course, this isn't an exhaustive list. There can be many more examples, some of which are specific and relevant to your sector, industry, or even business. And like I said, in those that first poll, some of those, you know, on the face of it, they would pretty much be your misconduct, but the circumstances around it, which I'm going to sort of go on to share now, could really make the difference and potentially make them potentially gross misconduct. So from the list that I've just mentioned and shown on that first slide, some examples are perhaps more clear-cut in terms of constituting gross misconduct, such as your theft. But what about gross negligence, insubordination? What makes something gross or serious and therefore reasonable to deem it as an act of gross misconduct and therefore dismiss? Well, there are two things to consider. Firstly, is the allegation likely to be deemed a fundamental breach of the contract of employment? And by that I mean, what was the severity of the action, such as the negligence? What impact did it have? What is the nature of the act and the relevance to the employee's key duties? So can you still trust that person to carry out their duties? It's much more than just saying you can't. You simply, you know, you must be able to explain and show that you can't. And what was the nature and circumstances of the employer? Because there are some organisations and some situations that will undoubtedly have an impact on the organisation's reputation. You know, what is common in the culture of that employer? So, for example, swearing. In one work environment and business, it may be gross misconduct. But in another setting, it may be perhaps a daily occurrence due to that culture of that organisation. So what I'm trying to emphasise here is the circumstances very much go towards determining what is that gross misconduct allegation. These are all key issues that require consideration. And then the second thing to consider is whether the allegation is considered either deliberate, willful, or grossly negligent. So what I mean by this is whether there was a clear rule or policy in place at the time of the incident, and therefore would the employee have known in advance that their actions may be dismissible offence. And finally, taking account of the motivation, the intentions of the employee in what happened. These are really important factors to consider when you're weighing up actually what's happened. Is that now a gross misconduct allegation? And so what's really important is to recognise the various ways in which allegations can arise. And before I go on to this, I'm going to run a quick poll just to see what your views are on this. Sue, if you could kindly call up the poll.
Yes, here we go. I'm just going to launch that for you. So, do you think you can take action against a social media post? So it's either yes, it is in the public domain, no, it was sent out of work time and does not relate to work, or you're unsure. That's an interesting one as well.
It is.
Very topical. Oh, I think nearly everybody's voted that one. So brilliant. I'm going to close that and share the results with you.
Okay.
So majority do feel you can, but there are a few that are not so sure.
Okay. And that it is an interesting one, and I'm going to come on in this section to talk about that more, because as with anything HR people related, not everything is clear cut, and I'll come on to explain that actually for the 82%, yes, you can be right, but also for the 5%, you can be right, depending on the circumstances. So I'm going to explain that as we go through the webinar, but thank you.
Okay. Back up to you now.
Thank you. And so this is about how allegations arise. And as I said a moment ago, there can be many ways in which that can happen. So an employee can raise directly with you or another manager their serious concerns. And typically you associate that as the grievance. You or another manager may witness some incident, and in that typical example, then that's where the disciplinary process gets invoked potentially. And then you may receive written complaints from a third party. And in the world of social media and technology, you know, more and more complaints are coming through to organisations via their social media routes, you know, such as your Twitter. So that's another way in which a complaint, a serious allegation, can arise and be brought to your attention. And serious allegations can also come to light via social media itself. So if we think back to that poll, and care must be taken in that situation, and I'll come on to explain, but essentially there could be grounds for an employer reasonably taking action, but also there could be reasons in a separate situation where it's not appropriate. So it all very much depends, but in theory, yes, potentially a serious allegation can come to light via social media. So what is the risk in terms of employment tribunals? So when a serious allegation arises in the workplace, then it immediately presents a potential risk for the employer, because whether dealing with it inadequately or not at all, this can lead to tribunal claims. So depending on the situation and circumstances, you could see claims of discrimination. So we know the Equality Act protects employees from being discriminated and treated less favourably than someone else in the same situation because of a protected characteristic such as age, race, sex, etc. And so in the context of dealing with serious allegations, it's really essential that you're acting consistently in how you manage the issue. So that stems from how you manage it right from the outset, to when you're in a hearing and you're weighing up your decision making. You have to be mindful of how the company has treated others in similar circumstances before, in order to prevent a discrimination claim. We can then see breach of contract claims where the organisation breaches one of the terms set out in the employee's contract of employment. So in the context of this webinar, an example could be, for example, not following the correct disciplinary, dismissal or grievance procedures set out in the contract of employment. Or, for example, where termination has taken place, the correct payment, etc., not being offered, applied. And then we have, and we can see, constructive dismissal claims. And again, in the context of this organisation, in this webinar, Constructive dismissal is where the employee resigns because of the actions of the employer, and it's that resignation that in the eyes of the law is seen as a dismissal. So, for example, carrying out a suspension incorrectly or unreasonably can lead to a claim of constructive dismissal, which is why careful handling of suspensions is imperative, and I'll come on to that later. And finally, unfair dismissal, which is where the employer dismisses the employee, breaking the employment contract, but it's done so in an unfair manner or unreasonably, in that the situation didn't warrant the dismissal. And that's why it's so important to distinguish correctly up front if it's misconduct or gross misconduct. So in terms of unfairness, a dismissal can be found to be unfair in two key ways, both procedurally and also for the reason for the dismissal being deemed unfair. And interestingly, in respect of the procedure, it means that even if you have a good reason for dismissal, such as theft, you can still fall down at a tribunal if the process you followed is flawed, you did so incorrectly or insufficiently. So what sort of financial risk could you be facing as employers if an employee is able to prove their case at a tribunal and you're unable to defend it? And so whilst it's tempting to look at these maximum awards here, they're significantly high, particularly in regards to disability, age discrimination, it's actually more useful to look at the average awards column. But even so, these amounts are still significant and amounts you do not want to have to pay out. And these are just the awards for discrimination and don't allow for other awards such as your unfair constructive dismissal or loss of earnings or the legal fees that you incur for putting together a defence, and the management time and effort that goes into providing witness statements, responding and attending the tribunal, which tribunals can last a day, 5 days, 2 weeks, so all of that needs to be taken into consideration. So I thought I'd share those interesting statistics there from the Ministry of Justice. So that's the context, the reasons why it's important to understand if something's gross misconduct, the risk from tribunals. But what are the key actions for managing serious allegations safely so you can avoid that tribunal, or where you can't, you can at least have a good defence? So I've pulled together 10 key actions for managing serious allegations safely, but do please note there can be many other ways in which to safely manage a case in addition to these, which very much depend on the case itself, questions that come up from the employees through managing the case. Each case has to obviously be managed in its own set of circumstances. But essentially what I'm going to set through now are probably the most standard and actions to be followed. So firstly, it's really essential to follow your own grievance and disciplinary policy. And I said earlier that failure to follow your own grievance and disciplinary policy can lead to claims at a tribunal. So even if you have grounds to dismiss, if you haven't followed your policy, you can still fall down at tribunal. And a failure to follow the ACAS Code of Practice when managing disciplinary grievances, an employment tribunal can make an uplift to the award that's made to the employee by up to 25%. So it's really imperative that you follow your own policies and procedures. Secondly, is all about reasonable investigations, and reasonable is that word that can be troubling to many of us because it's not defined. So regardless of whether you're dealing with allegations under your grievance policy or using the disciplinary policy itself, an investigation is a fundamental part of both. The ACAS Code of Practice on Disciplinary Grievance requires those reasonable investigations. So what does a reasonable investigation look like? What do we need to consider? As I said, reasonable is not defined. But we know through case law and the ACAS Code of Practice, some of these, for example, are going to be relevant. So has the employee's versions of events been investigated fully for verification, not just what we think happened? Are there any key statements, reports, documents, or even footage which might shed light on or prove what happened that's not being collected? Have you been thorough? Investigations must be thorough. Have all fair avenues for consideration been exhausted? No stone should be left unturned. And it's really important to not just take one side, one view. You've got to be impartial and explore all avenues. And as I say, no stone should be left unturned. And notwithstanding all of this, the investigation should avoid invading privacy unnecessarily or involving more people than is required. So there's a lot to consider around reasonable investigations. Follow your procedure and ensure that the investigation piece itself is absolutely thorough and watertight, because eventually it underpins the next stage of your process. Number 3 is all about when to address allegations raised via social media. So now I'm going to talk about this for a moment. So allegations, as we know, can arise via social media, but care must be taken. There is that balance to strike between an employee's right to a private life outside of work versus the reputation of the business. As an employer, you may be able to act under your internal policies if the social media posts call into question the reputation of the company, or if it's being used to bully or harass colleagues and it's being brought to your attention. So having clear company policies, including an IT policy or a dedicated social media policy, outlining expectations, rules of behaviour, and how employees should conduct themselves online is going to be critical in your ability to address. But essentially, where a social media post, as I say, brings a company reputation into disrepute, or is a form of bullying and harassment, you can legitimately have reasonable grounds for progressing and dealing with under your procedures. But as I said, take care, because it's striking that right balance between the right to a private life versus the reputation and any damage that's caused to the business. And then moving on to number 4 is all about suspension. And I mentioned this at the outset. The most important thing to consider when it comes to suspension is that it should not be a knee-jerk reaction. And we know that from case law. Where the decision is taken, that you need to, that you are suspending, then you must be able to demonstrate that care was taken in reaching that decision and that there was no other option that was more appropriate in managing the risks. Getting it wrong can lead to claims, as I said, at a tribunal from a constructive dismissal perspective. So if there is reasonable suspicion of gross misconduct, then suspension could occur and be justified, for example, where there's a genuine belief that there's a threat to the business or to other employees. You cannot properly investigate the allegation whilst that employee remains present. It may be, perhaps there may be a risk that they tamper with the evidence or destroy it, or where also working relationships are broken down, or there are genuine concerns for the health and safety of employees or others. So there can be grounds for suspension, but it should be a thoughtful process in how you get to that decision. And of course, suspension isn't always necessary and your only option. You may be able to separate parties, you may be able to put in additional checks or monitoring, or even temporarily remove an aspect of the role that removes that potential risk. But if no other option is appropriate and you've given that due thought to what needs to happen, then when you do suspend, make sure it happens immediately at the time the allegation comes to light. Don't delay. Evidence your thought process of what other options you considered and why they weren't appropriate, and confirm that suspension in writing. Suspension is always a period of fully paid period of leave, and it should always be under regular review and not protracted. These are all key steps when it comes to dealing with suspension when there's a gross misconduct allegation. Moving on to number 5 is all about your substantive justification and procedural fairness. So both is essential for that fair dismissal. Substantive justification considers the allegation itself in terms of whether it's legally capable of being grounds for undertaking that disciplinary action. So it must be identifiable as a breach of the disciplinary policy or some other breach, and therefore it justifies you starting disciplinary proceedings. And so this is one reason why we must have clear policies and procedures in place because we have to set out the expectations and rules of behaviour in our organisation. But in terms of procedural fairness, this covers every aspect from the process, from when the allegation is first brought to your attention through to the very end of the process. And it is all about adhering to your own policies. An employee should not be judged until they've been given full chance to prepare and submit their case. No decision is valid if the decision maker made a biased decision. That the employee should have notice of the allegations against them in advance, and that evidence that's being collected through your thorough investigation is also provided in advance of that disciplinary hearing, because they have the right to effectively prepare and participate in it. And they have the right to be heard when answering allegations. So there is a lot to think about, but these are just some ways in which you can ensure that you achieve that procedural fairness. So we're now moving on to the last 5 of our top 10 actions for managing allegations safely. And number 6 is all about whether that decision to dismiss fell within the band of reasonable responses. And we've got the word reasonable again. So we know it's not defined in law what we mean by reasonable. Each case will have its own set of circumstances, but a hearing manager will have several options in front of them in terms of what's available to use when it comes to the outcome. Dismissal is only one option. So whether the decision fell within that band of reasonableness is essentially based on the reasonable person test tribunal, which asks whether a reasonable employer would dismiss an employee in the same circumstances. So when you're in your decision-making process, when you're in that adjournment, I would say consider factors such as the employee's length of service, for example. We know that length of service tends to be looked upon favourably by a tribunal. Consider the employee's previous disciplinary record, whether they have shown remorse and their subsequent conduct through the proceedings, and crucially whether you have the confidence and reassurance from the process that the matter is not likely to be repeated again. And I say this is crucial because the purpose, the aim of any disciplinary hearing is to correct and change behaviour, and you need to get confidence and assurances from that process to ensure that you take then the right action. That's what you're looking to ascertain, that matter is not likely to be repeated. It's not a punishment, it's about how you deal with that behaviour appropriately. And also the sanction must also fit the crime, i.e. not be too harsh. And then when we move on to number 7, it's about whether you have reasonable grounds for holding the belief that the allegation occurred, and therefore the action you are about to take is justified. So again, it's that word reasonable, and so it's looking at in terms of the employer considering whether it's reasonable to interpret the evidence available to mean the employee committed that gross misconduct allegation, or could it be interpreted differently? The focus on this requirement is on reasonableness of perceiving the situation and the evidence as gross misconduct. So you don't have to prove beyond reasonable doubt. When you're in that adjournment, it's not a criminal court that potentially, you know, if anything gets to a tribunal, but you have to form a reasonable view on all the evidence. And that's why a thorough investigation is needed, because by having concluded that thorough investigation, it's given you all the available evidence to then form that reasonable view on it. And therefore, whether you think it's more likely than not, if you think of weighing scales, if the evidence tips in favour of actually, yes, gross misconduct's occurred, that's showing that you've held reasonable grounds for holding that belief. And then moving on to number 8, it's all about the right of appeal. And in UK employment case law, an appeal is generally regarded to be a significant part of a legally fair procedure. Not to offer an appeal may render a dismissal unfair in an employment tribunal, even if that reason for dismissal was fair. But additionally, the ACAS Code of Practice says that employees should be given the right to appeal against a disciplinary or grievance outcome. And where that's not offered, then it can go against you at an employment. And as we know, Tribunal can make an uplift to the compensation award that's made to the employee by up to 25% where there's been failure to comply with the ACAS Code of Practice. And now we move on to an interesting one, which is all about allegations raised by former employees, which is very interesting because perhaps you might not think that there needs to be done with that because they're no longer your employee. Well, we know that employees have 3 months less 1 day from the effective date of termination in which to raise an employment tribunal claim regarding constructive and dismissal claims. When you think of discrimination claims, these must also be raised within 3 months of the acts of the unlawful discrimination at an employment tribunal, and they can be brought within 6 months in a civil court. Tribunals want to see that employers have attempted to appropriately resolve matters internally before getting to the courts as well. And therefore, it's important that when dealing with allegations that are raised by a former employee, that you take the appropriate and necessary action. Now, interestingly, the ACAS Code of Practice on disciplinary and grievance is actually silent on grievances raised by ex-employees. So therefore, it implies that it just relates to your existing employees. But under the Trade Union and Labour Relations Act of '92, that deals with current and former employees, and specifically Part 4 of that Act deals with the requirement for codes of practice issued by ACAS to be adhered to. And so, you know, this legislation also applies, as I said, to current and former employees. This therefore presents the argument for using the grievance procedure after employment has ended. Clearly, if you're presented with complaints of serious allegations from an employee who's not long left the organisation, you are going to want to address it. Not only is it the right thing to do, but it could prevent issues escalating to tribunal. But also, if there was any wrongdoing, the fact that you have looked into it and addressed it prevents the wrongdoing occurring again in the future to others in the business. And in terms of the uplift in awards that I talk about, in terms of where there's been that failure to deal with grievance procedures, full grievance procedures, we can look at the case of Base Children's Wear Limited, and I've provided a link here, and you will all get copies of the slides after the webinar. And it was in this case that the Employment Appeal Tribunal found that in the circumstances, it was reasonable for the employer to have followed its full grievance procedure when the grievance and subsequent appeal had been raised after employment had ended. So even if a former employee raises allegations outside of the 3 months, a reasonable employer will look to take steps to explore and establish the validity of any claim in line with the implied duty of care to protect employees at work. So for me, that's a really interesting one, and perhaps not necessarily clear either. And finally, number 10, I've identified as being about taking commercial action. So there are occasions when organisations wish to take a commercial approach in resolving workplace concerns using settlement agreements. It doesn't have to mean that they are accepting liability for what has occurred, but it can be a more efficient and cost-effective way in which to close the matter down and ultimately part ways with an employee without repercussions of an employment tribunal. In some situations, the time, effort and costs involved in defending a tribunal claim can outweigh the cost that could be made to the employee via settlement agreement. Of course, for some organisations, the principle of the matter outweighs the potential cost, and they therefore wish to fight the case at tribunal. It is very much an organisation by organisation view and culture. But it's usually helpful to gauge towards the end of any internal process, whether that's your disciplinary or your grievance process, if there are risks on the case, and if so, to what extent, and what are the prospects of success if it was to go on to become a claim at tribunal, before then deciding on whether to enter any conversation about parting ways. I guess this last action leads us nicely onto next month's webinar in July on the 17th, as we are going to be running a webinar all to do with protected without prejudice conversations. So if that's an area that you'd like to find out more about, then be sure to join us on that one. And now this concludes our webinar. So I'd like to open up for any questions if we've had any come through. Sue?
Hi, Victoria. No, we haven't done any questions today that I haven't dealt with directly for various reasons. So no, I think we could continue.
Okay, brilliant. Thank you. So I'm just going to run through the remaining slides. We do have one further poll, and it's really to do with if you'd like us to follow up with you after today's webinar. If so, then please do let us know what it is that you'd be interested in finding out about. And that could be our HR services, HR training, the knowledge base, health and safety services and training, or payroll. So please do let us know and we can follow up with you.
Okay, just let a few more come through.
Thank you.
Okay, I'll close those off now for you.
Thank you very much, everybody.
Okay,
Sue.
thanks. Over to you.
Thanks. And as always, we like to inform everybody about events that we have coming up. So on this slide here, we do have a couple of training courses coming up. Very nicely to this webinar, actually. We've got an equality and inclusion training course. It's a half day. It will be remote, obviously given the pandemic situation at the moment, but it's going to be on the 28th of June, 1 o'clock till 4:30. And we're also running a Grievance training session on the 14th of July, 9:30 to 1 o'clock. Again, it will be remote based, obviously given the circumstances at the moment. And we're pleased to announce that our training content constitutes CPD points, so you'll be able to earn those by attending. And I just wanted to let you know that we're currently working on our new training program, and we have some new training courses coming up for, I believe, September time. So please do keep an eye out on our website for any new developments in regards to that. And in terms of upcoming webinars, I've also mentioned already the one in July. Sorry, it's the 15th of July. I think I might have said the 17th. And it's What Are Protected or Without Prejudice Conversations. And that's Thursday, 10 o'clock till 11 o'clock. And then I'm going to be running a webinar in August on the 12th, which is all to do with remote working and how can you manage performance. We are going to be looking at a new webinar program as well coming soon. So please do keep an eye out on our website, on the knowledge base, for details of that program. Here we have just a summary just to let you know about the Disciplinary and Grievance training course that we're running. So it looks through the basic process of dealing with it, how to deal with that investigation, which obviously I've talked about is essential for any process. It underpins it, and the need for getting a formal process and an outcome in the right way. So that's going to be on the 14th of July, and the details here for how you can join us and sign up to that. We then have training in regards to first aid for mental health. As you'll probably know that we're seeing an increasing amount of mental health, ill health occurring in respect, as a consequence of the pandemic. So, and we are seeing more and more organisations use mental health first aiders. So if this is something that you're interested in, then we do run a mental health first aid training course. And that's on the 24th of May. Oh, sorry, I don't know, then it will be a new date, sorry, because we're obviously past May. And then newsletter, so we do want you to stay in the loop with and be amongst the first to be invited to our webinars. So you can do so by joining up to our newsletter here via this link. And that concludes our webinar today. So if you do have any further questions, then please do get in touch with us on the information on the screen here. Copies of our slides and the recording will go out to you all after the event. As always, we really appreciate your feedback. So after today, we'll be sending a short survey to capture that, and we would really appreciate it if you could just take a few moments to complete the survey so that we can constantly improve our services to you. And that's just to conclude today's webinar. So I would like to thank you all for attending and taking the time out. I know everybody is busy. Thank you to Sue and the team for helping and supporting the running of the webinar. And I look forward to you joining me on future webinars. Thank you all, everybody.